And when I say up north, anybody from the Midwest in particular knows, Wisconsin as well knows that up north doesn't necessarily mean, physically up north. We're obviously talking about, family properties, whether that's a cottage or, a cabin in the woods, hunting land, family property that you're trying to pass on when we're referring to up north property. And just a couple quick housekeeping items before I go into too much detail. At the end of this, like always, you'll receive a feedback form and our handout. So our handout actually is tools for protecting up north properties, this little chart right here, which gives you a couple different ways that people might look at passing on the family property and some of the pitfalls, pluses and minuses of each. But then the feedback form that you'll receive via email also gives you a place to let us know whether you'd like us to reach out to you to set aside time to talk about either planning around your family property or estate planning questions, set up an initial consultation to do that. So that form lets us know to reach out to you to do that. Otherwise, we don't reach out to you without your permission. So it's very important to fill that out if you'd like us to. But those initial consultations are complimentary, so they don't cost you anything to come in and talk to us. We set them up for 2 hours or so. It maybe doesn't take quite that long. Sometimes it takes a little longer depending on the topic at hand. But that time really helps us kind of help you figure out what the best plan of action is for you. We do ask for quite a bit of information that you bring in, a lot of financial statements, any previous legal documents that you might have, some family information, but that's really to help us give you the best, design for your plan. And then just a reminder that next week is actually our upcoming in-person public seminar here in Appleton. And that'll be at the Bordini Center for Fox Valley Tech. It's our wills versus trust seminar. That is, there's 2 sessions from 2 to 4 and then 6 to 8. So please, if you are interested in attending that, register for that, and we will, put you down for that. Space can be limited, so the sooner you do it, the better if you're interested in attending. Okay, so getting started with up north properties or family properties in general, one of the biggest concerns people have is not necessarily just liability during our lifetime, although that can be part of it, certainly, but it's also, how do I make sure that this passes on in a way where I have it set up well for the next generation to deal with things like usage or valuations or sales of the property, or just making sure that the family property actually keeps the family together and doesn't drive a wedge in between people. One of the most common issues with hunting land, with lake homes, family properties that have been in the family for a couple of generations, or maybe just that one generation at that point, is that it's not set up to deal with those sorts of disputes. The way that it's being passed on doesn't deal with that. And the biggest issue people run into with that lack of planning is that it does end up driving a wedge between one or more of the family members because they do disagree on how to handle things, or there isn't a guideline for them to follow on how to deal with those disputes. So when people just leave property to the next generation of, we have 4 kids as an example, they just share the family property equally, they each own a quarter of the property. Well, maybe there wasn't an issue known at that time. Maybe they didn't have disputes prior to that point. But what happens if one of those people wants to sell their interest because they either don't have an interest in owning it, or they don't want to continue paying the expenses, right? I mean, how does that get dealt with if there's no structure in place? And that can be very difficult where not everyone agrees on the outcome there. If 3 of those 4 people don't want to sell, or and only the one does, that one person is going to have a very difficult time actually selling their share unless the other owners want to buy it from them. And that's not always feasible. I mean, there can be reasons why somebody financially can't do that, right? They may not have the money available to purchase the other person's share, but that one person looking to sell is also going to have a really hard time finding somebody who's willing to buy into that family's ownership of the cabin. Because if you think from your perspective, how likely are you going to want to buy a portion of ownership of a lake home, for example, that a bunch of other people you've never met own? It's unlikely to be a successful endeavor at that point. Most people are not willing to purchase something like that. So you need some other plan in place. And there's sort of two sort of time components or time frames where this type of planning might be done. Obviously, if it's just you and a spouse who owns this property right now, that's the easiest time to start this planning discussion, because the only people who have to agree on that planning are you and your spouse. So if you don't have that structure set in place, you can set it up with just the two of you initially, and then make sure that that rule book, so to speak, is in place for the next generation. If you are already the maybe subsequent generation, the second generation to own it, or you bought into that property maybe with family friends or with siblings, so it's already multiple families owning that property. It obviously is a little more complex to do that planning, because those different families might have different goals of how to pass on that property, or what kind of rules they want in place, and you're going to have agreement on those rules when you put them in place. So it's obviously easier to do that planning when it's just a spouse, because then you have fewer people who are potentially disagreeing with the rules being put in place, and less hands in the kitchen, so to speak. But when you do have time to do that planning, even if it's multiple families owning the property, it's always better to deal with that issue now, as opposed to wait for yet another generation to take that on. Because the more the generations go on, the more owners you're likely to have on that property, and that can be really disruptive. The more people involved, because how do you get more and more and more people to agree on doing planning around that property? If it was already hard with 4 people, it's going to be even harder with 8, 16, right? It's going to be that much harder. So lifetime planning is essential. Having those discussions on how do you want to restrict ownership? Do you want to keep the family and only the direct family involved in that property? Would you want a child to be able to involve a spouse, or do you want to limit the number of owners that can possibly have ownership in the property at any given time, so that you don't end up with the 16 owners at some point? Maybe you want to limit it to a certain number of people. Those are discussions you want to have now while you're still able to do that planning. You don't want to wait for your family to have that discussion later on, because it's just much more likely that there is going to be some sort of disagreement, or that they are, they're going to have different ideas of what they would want to do. And so it's easier for you to put those in place while you're still able to. So the lifetime planning I mentioned, the big decisions I'd want someone to think about is, how do you want that ownership to work going forward? So do you want it to be that basically somebody can't sell their interest, or that the family has a right of first refusal? Do you want to limit the ownership in any way so that spouses can't be involved, or maybe only one child per family member can be involved, so that you keep the ownership number the same? And if you would like them to be able to sell their interest, if they're no longer able to cover expenses, or just don't want to be a part of it, how do you want that to work? How do you want that valuation to work? Do you want it to be fair market value appraisal? Do you want it to be discounted in some way so that it's easier for the other family members to buy out those shares? It can be done a number of ways, but you want to set up those rules and determine how you would like to see that done. And it can be done a lot of ways. Like I said, I've seen people not want it to be a value that they would receive unless all of the owners agreed to sell it, so that one person trying to sell, they maybe can just forfeit their interest over to the other owners, so that they don't have to pay expenses anymore, but they may not get anything for value in that example. But that's not true of everybody. So you just need to sit down and have that discussion. In terms of, whether spouses are involved is a really big kind of driving wedge between people. How do you want expenses to be paid? How do you want usage to be determined? A big problem, obviously, when we're talking about more and more people owning a property is who gets to use it when. Obviously, everybody's going to want the lake home on the 4th of July, on Labor Day weekend, on Memorial Day weekend, right? The big weekends of the, lake season, if you will. So is there a structure you're putting in place that, they have to use to determine usage? Is there a calendar that, they have to have a meeting at the beginning of the year, the family being they, and sit down and each person gets one weekend, right? That kind of thing. You can set all of those rules up. So how to set those rules up, though, is an important factor in this as well. When you talk about transferring that property after you've passed away, the way in which you transfer that property is going to dictate how much of a restriction you can put on that property. If you just have a transfer on death deed, for example, to the 4 kids equally, you're not really putting any restrictions on that. You're just saying, all right, you own it when I die. So that's really not what I would consider an ideal plan for that type of property, because you're not really doing anything. You're just transferring it, which is part of what you're trying to do, obviously, but it doesn't provide any sort of guidelines to those new owners at that point. Do you want to use some sort of trust to transfer that property, or a business entity to own that property, right? Those are important things to talk with an estate planning attorney about to determine what's best for your situation. Or do you use some combination of a business entity and a trust? So one way that we often look at planning for family property is setting up something like an LLC, for example, to own that property, both during the original owner's lifetime and as a way to pass it on potentially through their trusts that they have, or for the family to buy into at some point, right? So the LLC provides a guidebook for the family. It's a business entity that both provides liability protection for the owners from the liability of that property, but it also allows the owners to decide, okay, if somebody is going to sell their share, how does that work? What appraisal process do we have to use? Who is allowed to be an owner without having all of the other owners agree to it? Can it be a spouse, or does it have to stay a direct descendant of ours, for example? LLCs, other types of business entities provide you that structure. LLCs are definitely the most common to use for that type of planning, simply because they provide the liability protection for the owners, but they also allow you to have the guidebook, the operating agreement for that LLC that tells the next generation, if they want to be a part of this, here's the rules in place. Why that's easier to do originally during your lifetime than it would be to have the kids set that up later on is simply because when you're creating that LLC, all of the original owners of that property have to agree to the terms, right? So if you have more people involved, you are going to have more potential points of conflict, right? Where people don't agree on how that should be set up. So always easier to do it sooner rather than later, or before the next generation inherits. If you're already in that second generation, it's still not too late to do that, but you are going to still have to have everybody agree. I've had families on both sides of that where they've done parents have done the planning ahead of time because they want to avoid any sort of dispute going forward. I've also had it the other end of that where thankfully there wasn't a dispute now, but the next generation already owned it and they were looking to avoid that dispute for the following generation, right? It was already siblings owning it. And they wanted to make sure that once you got to like nieces and nephews and things like that for everybody else, that they weren't going to have disputes. So doing that LLC planning as an example, earlier rather than later is a good idea. It also during your lifetime does help provide some liability protection, so that if you don't live on that property and somebody's trespassing while you're not there and it's empty at the time and somebody gets hurt and tries to sue you, that you limit your own personal liability as much as you possibly can. And liability insurance, of course, helps with that as well, but they function from a sort of a different angle, if you will. With trust-based planning, you can also provide these sorts of rules for the next generation in like a cabin trust or some sort of trust setup for the next generation as well. That can work depending on the situation. That's really where you set up the rules going forward, especially if you don't want them to be able to decide, them being the next generation, to be able to decide where that goes after they pass away. If you have predetermined that, you don't want to have anybody change your own rules. Having a trust in place rather than just an LLC, for example, would make it more difficult for them to change the rules. It's still not impossible, but it would be more difficult. With LLCs, as long as all of the owners of the LLC agree, they can change the rules. So if they don't like the rules you put in place and all four of the four kids say, we don't like what mom and dad told us to do, they could decide to change those rules. So that's why it's important to have these discussions with the kids too now. And that's one thing I didn't mention during the lifetime planning, component is sit down and talk with the kids, see if they actually have any interest in owning this property, or if they would just look to sell it right away. And if there's disagreement on that, if one kid would want to sell it, but the others just say, no, we want to own it, that might impact how you leave that property. Do you leave them equivalent value from a cash asset instead to the person who wants to sell that property versus the actual ownership of the property, so that they're compensated for it? But then you don't have the dispute of, well, I want to sell it, but none of you are willing to buy it, right? Having the discussion now, if you find out that none of the kids want it, right? If they would just sell it, turn around and sell it, why would you do any sort of intricate, planning around restrictions on sale and ownership and usage rights? If the moment the kids inherit it, they're just going to turn around and sell it. And there's nothing wrong with them wanting to do that, of course, if that's their goal. But it would be a huge waste of your efforts to sit down and do all of this, really involved planning, which can be great planning if it's just going to be undone the moment the kids inherit it because they have no interest in actually owning it. So this is also where a discussion of fair and equal can be a very different discussion, right? In terms of equal inheritance, yeah, everybody inherits equal shares. If that's equal value, that's what that would mean. But maybe it's not fair to the others if one person's put a lot more into, like, a family farm, for example, or improvements into the lake home. I mean, whatever they're trying to do to add value into it. If one person's put a lot more into that, well, equal might not be fair either, right? So those are also discussions to have. It also might be a matter of, if this person's just going to want to sell it, but we don't have equivalent value from other assets to sort of make up for that share, to sort of compensate them so that the others can continue owning it, it might be a matter of having a discussion of, one, do we sell it during lifetime to the kids that want to own it so that they can decide to do that? And then, there is value to compensate the other person, or do you just not leave a share to that one person because it would make it unworkable for the family? Obviously, that's always something people try to avoid, but there are definitely times where if the only asset is this one, vacation property, really, and one person doesn't want to own it and would just want to sell it, and there's not cash assets or other value to compensate them for what would be their fair share or their equal share, it might make it more workable for the other owners to not have to deal with it going forward. And you just say, okay, well, if you want to be involved in this property, you can have it as part of this planning. But if you don't, you're not going to receive any value for it, right? And that's a discussion that you have to have. That's a decision that has to be made. And there's a lot of different components to that, obviously. But this is why it's so important to do this planning ahead of time. Because if you don't do this planning and you leave these discussions up later, you do run into the risk of they're gonna have these disputes anyway, right? If they have to make these decisions and you haven't had the discussion with them, or you haven't made the decision ahead of time, and you don't know how that discussion would play out, you're just running the risk of this property that's meant to keep the family together really driving them apart. I often get people who will say, well, they get along now, and that's great. But my next question is have you ever even had these conversations with them? Because if you haven't had these sorts of conversations with them and you don't know whether they would cause disputes, whether or not they get along now is going to be completely irrelevant if those are the current sort of pain points for the family of, well, so-and-so would want to sell it, but I don't think that's fair. You want to have that discussion now, not have them have that discussion after you've passed away, especially if the goal is to keep that property in the family and keep the family together. One of the huge benefits of doing the planning around LLCs or around trusts while you're still living is that just like the LLC can provide liability protection for you, that can also provide liability protection continuing on for the next generation as well. Especially the more owners you get involved with any sort of property, the more people that might be on the property at any given time, the more that protection is valuable. You don't want I mean, if you could think about like an extended family member, for example, bringing all their buddies onto the property one time, and maybe that's the cousin in the family that nobody really gets along with and nobody trusts, right? This would be an extreme example, of course, but just to keep it in mind, that maybe is why that liability protection would be so important. Is maybe you say, oh, cousin Johnny is really not trustworthy. We're really worried about what he's doing on the property, and we're worried that that could impact us. Well, if the generation prior to that had set up some sort of liability protection through like an LLC or some other limited liability type entity, then you're doing that planning for the next generation as well. It's not just for the current generation. So what's really, really important though with LLCs is to make sure that in addition to actually having an LLC and having the property owned by that LLC, that you have an operating agreement, a written operating agreement in place for that. So one of the most common issues I run into with, and not just cabin LLCs, not just hunting land LLCs, but actual business entity LLCs as well, people who are operating a business, is that they have an LLC, but then they have no written operating agreement. So if you're unfamiliar with what that is, a written operating agreement is not the like printout of the articles of organization that you get from the Wisconsin Department of Financial Institutions, right? That's the articles of organization basically saying, yes, I have an LLC, here's the name, here's the registered agent on it, like all of those sorts of things. But it is not an operating agreement. An operating agreement is the rule book for the LLC, rule book for that business entity. So that's where you put down sorts of transfer restrictions of who can be an owner of this, what's the appraisal process for value, what sorts of management structure is there for the entity. Do you have one child who is going to be the manager of the LLC and make the kind of executive decisions, or do you want more of a kind of board of directors so that they have to all be involved and agree on things? There can be a lot of different structures for this, but that's what the operating agreement lays out. If you don't have a customized, one that you've had drafted for yourself, an operating agreement, then you're currently using the default statutes under Wisconsin law, which can be very dangerous because most people don't know what those say unless they, for example, are an attorney who reads them. I don't run into too many clients who have sat down and read through the statutes, almost none, to be honest with you. So it's really important if you don't know what those rules would be, or if they, more importantly, don't follow what you would want to be the rules, you have a custom operating agreement drafted so that you can lay out how you want that to work. One sort of consideration with the next generation too is payment of expenses and how is that allocated. Sometimes people might run into hard times where they're not able to continue paying their fair share of the expenses for the property that you've passed on. How do you want that dealt with? Do you want it to be that if someone continually can't pay their fair share of expenses, that they maybe slowly, transition ownership over to the other owners who are recovering those expenses? Do you want it to be required that, somebody pays those expenses, but that person doesn't necessarily lose their ownership? Those are really important things to factor in because there can be a lot of reasons somebody can't cover those expenses. Is somebody doing it because they're just choosing not to, or do they have some sort of financial concern that's getting in the way of them being able to, right? Do they have health concerns or anything like that? With passing on the property too, you now also have to worry about things that can impact the ownership of that property for those people. What I mean by that is what happens if they themselves have like a lawsuit or a disability? How do they protect the property from those things happening to them? And this is where you can have a bit of a combination of planning options, sometimes both an LLC and using a trust to do that. And it can provide protection from sort of two angles for them. One thing that is happening more and more, as an example, would be things like somebody inheriting at a time when they themselves might be close to needing some form of long-term care. The longer people live, the older their kids are when they inherit, the higher the chance is that they themselves are going to have some sort of health concern that might lead to them needing some sort of assisted living or skilled nursing care. So having protection planning in place, not just from the liability of the business, or of the property itself, so that, if somebody gets hurt on the property, they can't sue the kids. Maybe, or in addition to that, you want property protected from the liability of those children too. And not necessarily saying they're irresponsible, but I mean, just the things that can happen in people's lives that are unpredictable, right? And the number one way to not have any of that planning is simply to just pass the property to the next generation without any other sort of structure in place. I mean, once you're the owner of that property, if it's not in some sort of, limited liability entity, if it's not in a, sort of asset protected trust, for example, you don't have any of that planning in place. One thing to just to round out the discussion to finish up is to also address when the unforeseen can happen. So if you have the most trustworthy family right now, there are no concerns, you don't think there's ever going to be anything that could come up as an issue. Well, what happens if the planning you have in place now doesn't address those unforeseen circumstances at all? So what happens if somebody passes away before you? Does that impact the planning at all? What happens if they get divorced, or they get sued for some reason, or they do have an unforeseen like substance abuse issue? What happens with that property? Are they still able to control it? Do they still have an interest in it? Or does that change your calculus on that? So I'm raising a lot of questions because these are questions you're going to have to address as part of this planning. It's not something that it's not something that you want to leave not discussed. You want to discuss it with the family. You want to discuss it with your spouse so that hey, if this sort of thing happens, what would we like to see be the end result, as or what would we want in place to deal with that concern, right? And I mean, the number one thing though is definitely talk with the kids first before you start going into like in-depth planning. I've had a couple of discussions in the past where people say, well, we really want to set this up for the kids. We want them to do it X, Y, and Z with it and be restricted in this way and that way. And we want to force them all to be involved. But then the moment I ask, well, have you ever even talked to the kids about whether they want to own this property? You'll either get a no back or kind of, well, not really. So talk with the family, make sure they actually want to be involved in that property. Because if you just decide after talking to them that, yeah, they really have no interest in this, why do all that intricate planning to force them to be a part of something they don't want to be, right? So talk with them. And then just to wrap things up again, keep an eye out for that email after this is over, where you'll get the sort of up north property chart again, or how to pass on that and different ways to plan around it. And then also the feedback form, where it lets you let us know if you'd like us to reach out to you to set aside time to talk about whether it's planning around your family property, estate planning questions, elder law questions. And again, those are complimentary initial consultations set up for about 2 hours, and we ask you to bring in some information, quite a bit of information on yourself, finances, and family, so that we can help you do the planning. But if you're interested in that, please let us know through that feedback form. And if you are interested in the next week, our public seminar, please feel free to sign up for that as well. That will be again in Appleton at the Fox Valley Tech Bordini Center, right across the street from our office, actually. So with that, I will let you guys go enjoy the rest of the nice day outside, and I hope to see you all next week.